We are Project 3 and welcome to our podcast. Join us as we dive into the complexities of environmental sustainability and explore the role we can all play in creating a more equitable and sustainable world. Starting with your host, Kiara.
For today's episode, we'll continue talking about the importance of media law and ethics in media industry. And as you may have noticed, we're focusing on the media industry in Pakistan. An atmosphere of intolerance in South Asia discourages free expression or opinion. Laws based on security must be reviewed in a world where information can be received through electronic media or internet. It is essential to draw some minimum guidelines to make the right to information effective. According to PEMRA, Ordinance 2002, the authority has mandated to, number one, improve the standards of information, education, and entertainment. Number two, enlarge the choice available to the people of Pakistan and the media. Number three, facilitate the devolution of responsibility and power to the grassroots by improving the access of the people to mass media at the local and community level. Number four, ensure accountability, transparency, and good governance by optimizing the free flow of information. The law lays down stringent and subjective precondition for eligibility of a license, says a broadcaster or CTV operator issued a license under this ordinance must, among others, guarantee the following: a respect for the sovereignty, security, and integrity of Pakistan, be respectful to the national, cultural, social, and religious values and principles of public policy as enshrined in the Constitution, and ensure the programs and advertisements do not encourage violence, terrorism, racial, ethnic, or religious discrimination, sectarianism, extremism, militancy, or hatred, or contains pornography or other material offensive to commonly accepted standards of decency. The Electronic Media Regulatory Authority Ordinance is also arbitrary and in violation of the international standard for free flows of information and retains the infamous system of licensing without defining eligibility in unambiguous terms. The obligation imposed on private television channels to telecast programs mandated by the authority, and it appears to be a device to commission them for official propaganda. The ordinance is also silent on the decades-old, persistent public demand for freeing Pakistan Broadcasting Corporations and Pakistan Television Corporations of official control, and it shows little respect or concern for the viewers' needs, taste of Pakistan's pluralist society. The current Pakistani media landscape reflects a multilinguistic, multi-ethnic, and class-divided society. There is a clear divide between Urdu, national language, English, official language, and media. The Urdu media, particularly the TV channels and newspapers, are widely viewed and read by the masses, both in urban and rural areas. However, the English media is urban and elite-centric. English print, television, and radio channels have far smaller audiences than their Urdu counterparts, but have greater leverage among opinion makers, politicians, the business community, and the upper strata of society. Before 2002, the Pakistani's electronic media was under heavy control of the government, and new developments in electronic media in Pakistan started in 2002 with promulgation of the Freedom of Information Ordinance of 2002 and the Pakistan Electronic Media Regulatory Authority, or PEMRA, Ordinance of 2002. The Freedom of Information Ordinance contains positive features acknowledging citizens' right to know. To bring its vision of liberalized media in the country, the military government of Pervez Musharraf promulgated PEMRA Ordinance in 2002 to establish Pakistan Electronic Media Regulatory Authority. Mandate of PEMRA is to improve the standards of information, education, and entertainment, and to enlarge the choice available to the people of Pakistan, including news, current affairs, religious knowledge, art, and culture, as well as science and technology. To meet this mandate, the ordinance provided to open up broadcasting media for private sector. In addition, it contains provisions to regulate the operations of all the broadcasters and cable television stations established under this ordinance. After promulgation of above ordinances, a number of private TV channels have got licenses to operate in Pakistan. According to the PEMRA statistics, more than 80 satellite TV channels were working in the industry at the end of the year 2013. Licenses are granted in categories of education and news and/or entertainment-specific channels. This progress has led to a new era of information age in the country, with many TV news channels both in English and Urdu languages. These channels immensely compete among themselves for market share. This competition is, further, toughened by the landing rights given to foreign channels such as CNN, BBC World, Sky News, and etc. to operate in Pakistan. Although English channels have their place, however, cutthroat competition is observed among major Urdu news channels such as AAJ, ARY, Dunya Express, Geo, and Samaa news channels. Media landscape is quite vibrant, and the channels enjoy independence to a large extent. This fierce competitive environment has both its pros and cons. Defamation laws spring from law of torts. Having its roots in English common law, Salmon defined tort as a civil wrong for which the remedy is common law action for unliquidated damages, and which is not exclusive to breach of contract or the breach of trust. The word tort comes from the Latin word tortum, implying to twist, meaning thereby behavior or conduct that is tortuous or wrong. It corresponds with the English word wrong and the Roman word delict. When actions are twisted, this is the opposition to actions that are considered right. To be a tort, an act, whether commission of it or omission of it, must be wrongful. This wrongful action must result in damage. The damage may be either legal terms or actual terms. The cause of redress as a result of the act must lie in a legal remedy or in an action of damages. Damages are monetary claim to damage suffered. The damage must be in real or legal terms. The party having complained must have suffered from a legal or wrong committed by the act of another. Law of torts basically is based on a simple, understandable, and local principle that any and every harm to another individual is lawful and thereby punishable. In these torts is a wrong that is deemed as wrong affecting one's reputation. It is known as defamation. Defamation is described as an international false communication, either published or verbally spoken, that injures another's reputation or good name, holding up of a person to ridicule, scorn, or contempt in a respectful and considerable part of the community. Maybe criminals as well as civils include both libel and slander. Defamation is that which tends to injure reputation, to diminish respect, to esteem, goodwill, or confidence in which the plaintiff is held, or to excite adverse, derogatory, or a pleasant feeling amongst any against him. Statement that exposes person to contempt, hatred, ridicule, or obloquy. Slander will be described as speaking of base and defamatory words tending to prejudice to another in his reputation, community standing, office, trade, business, or means of livelihood. So slander has certain basic ingredients. Number one, it is defamatory. Two, it is oral. Three, it must lead to damaging another's reputation. Person against whom slanderous comments or opinion is made to is contempt to file a case against the person committing the offense. The onus to prove that slander was committed lies on the plaintiff. He must prove that the communication took place and that it is defamatory. It must not be a fair comment on the person or an institution. This then will not only constitute slander. In slander, the person bringing about the case must provide that special damage has resulted owing to the slander. An interesting example of slander would be from July 7th, 2012, when former Chief Minister of Punjab, journalist and news anchor Nahan Sethi announced to have sued renowned journalist Mubashir Luqman for arrest $0.1 billion alleging defamation. Documents reveal that the case was based on statements by Luqman in his program Kahara Sach on Doing News to be false and malicious allegations due to the tense political situation at the time in the country, especially higher level of anti-Americanism, intentionally aimed at provoking and enticing mobs or extremists to engage in physical violence. Libel is the second kind of defamation. Here the ingredients of libel are: words stated must be defamatory. It must be in the form of permanent record that can be referred back to, and it must refer to the person of the plaintiff. Like an actionable per claim of damages for publication of defamatory statement, while determining damages due to regard has to be taken of following factors: nature of defamatory statement, conduct of person responsible for its publication, conduct of such person after issuance of notice and after institution of case, degree of care and caution exercised before publication of disputed statement. Each time of slander and or libel is repeated, it becomes an offense, and the offender is liable to be brought to the court for the offense every time it has become cause for a new case. There are many grounds on which damages can be aggravated or mitigated in case slander and libel. There are many grounds on which damages against the offender can be mitigated. If the accused apologizes at the first opportunity, court will take cognizance of the fact. If the evidence falls short of justification, for example, if the case is not strong enough and does not provide guilt to the accused, absence of malice will be also an important factor in determining and adjusting mandates. The court will also keep in mind if the plaintiff is in habit of libeling the defendant and if the reaction is the plaintiff and it is also doing or saying something falling within the purview of defamation against the defendant. This will be duly considered by the courts. Also, if the plaintiff has far from a clean reputation, courts will take none of this into consideration. This does not mean to say that if someone has a doubtful reputation, anyone can get away by saying anything about his or her reputation. What it does mean is, if the plaintiff has a bad reputation, it is easy for another to be taken by a negative news related to the plaintiff. That's all for this episode. Catch us in the next one as we dive into defamation as a continuation to this episode.